Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers interfering, pat-downs, and the First Amendment, and is brought to us by Duck to Police's channel and Lackluster's channel. Be sure to check out the description below and give them the credit that they deserve. This will be another double feature episode, so be sure to stick around for our coverage of both of today's interactions. On September 9th, 2024, a deputy with the Montgomery County Precinct 5 Constable's Office in Texas initiated a traffic stop on a driver who pulled into a gas station parking lot. The interaction that followed was captured on the deputy's body camera.
You gonna roll down the window? Why not? Roll down the window.
Yes, may I help you?
Officer Norton, Montgomery County Constable's Precinct 5. The reason I pulled you over is your license plate is obscured. I cannot see your license plate.
You're full of crap anyways because it's got my bicycle things on it.
It still can't be covered.
Yes, it's not covered. It is, but that's
It's obscured.
legal.
No, it's not. I cannot see your license plate. I cannot see your license
Okay,
plate.
fine, I'm sorry.
Okay, so it's obscured. Do you have your license on you?
Yes, I do.
Okay.
However, it's not obscured.
Okay, it is obscured.
You can call Officer Simpson, Sergeant Simpson, and ask him. It is not obscured.
So me not being able to see your back license plate, don't roll up your window on me.
Oh, watch me.
Okay.
It was an accident to begin with, so don't threaten me.
I didn't threaten you. I said
Yes,
don't roll.
you did. Don't roll up your window on me. It was an accident to begin with.
Okay,
It's wrong.
that's all I said was don't roll your window up on me. Where's your license?
It's not obscured.
Okay.
You can read it.
We can agree to disagree.
The deputy claims that the driver's license plate is illegally obscured by the bicycle rack, and the driver argues that it is not. Subsection A7 of Section 504.945 of the Texas Transportation Code states that, quote, a person commits an offense if the person attaches to or displays on a motor vehicle a license plate that has a coating, covering, protective substance, or other material that distorts angular visibility or detectability, alters or obscures one half or more of the name of the state in which the vehicle is registered, or alters, covers, or obscures the letters or numbers of the license plate number or the color of the plate. Now, while this could conceivably prohibit covering the letters or numbers of the license plate with a bicycle rack, the statute specifically states that, quote, subsection A7 may not be construed to apply to a bicycle or motorcycle rack that is attached to a vehicle in a normal or customary manner. Accordingly, it is highly probable that a court would conclude that the driver's license plate was not unlawfully obscured, and that, therefore, the traffic stop was unlawful from its initiation.
Where are you coming from today?
None of your business.
Okay, cool. Any weapons in the vehicle?
None of your business.
It is my business, actually.
No, I don't have to answer any more questions.
Yeah, you do. Are there any weapons in the vehicle?
Here you go.
Are there any weapons in the vehicle?
No.
Okay. Any illegal narcotics?
I'm not answering any more questions.
Okay. Cool. Go ahead and hop out of the vehicle for me.
Excuse me?
Hop out of the vehicle.
Excuse me?
Go ahead and hop out of the vehicle.
Say that again?
Go ahead and hop out of the vehicle.
No.
Get out of the
I'm not
vehicle?
getting out of the vehicle.
Yeah, you are.
Oh, no, I am not.
Yes, you are.
No, I'm not.
Yes, you are.
No, I'm not.
8520. Can you send me another unit? I have a occupant that's refusing to get out of the vehicle.
I'm not getting out.
Yes, you are.
Clear. Can I get a second 85? All units be advised, shuttle sport cover closed, shuttle sport cover closed.
I do not have to answer any questions, and I am not getting out.
It's a lawful order.
No, it's not a lawful order.
Yes, it is. It is a lawful order, me telling you to get out of the vehicle.
I am not getting out of my
You can open up the channel. You can get out of the vehicle, or you can go for interfering. We'll sit here and all day. All I asked was for you to get out of the vehicle.
I am not getting out of my vehicle.
I don't know what's in this vehicle. You're not telling me if there are weapons. I asked you if there are weapons. You said I don't have to tell you.
No, there's no weapons in my vehicle.
You said I don't have to tell you.
There's no weapons in my vehicle.
Okay, cool. Well,
So I do not have to get out of my vehicle.
yeah, you do. It's a lawful order.
No, it's not.
Okay, we can agree to disagree.
I'm not doing anything wrong. There is no reason for me to get out of my vehicle, and I gave you my driver's license.
Okay, well, we can either pull you out.
Call Sergeant Simpson.
I don't need to call Sergeant Simpson.
Advisor.
He-
There is no reason for me to get out of my vehicle. I've not done anything wrong.
So me asking you is a lawful order.
No, it is not.
Yes, it is.
It is not.
It
I do
it
not
definitely is a lawful order.
my vehicle.
Okay.
It's not a lawful order because there is no reason for it.
Okay, she already locked it.
The deputy threatens to take the driver to jail for interfering, for refusing to get out of his vehicle, arguing that it is a lawful order. As we have discussed many times before here on ATA, the Supreme Court held in the 1977 case of Pennsylvania versus Mims that a police officer may order the driver of a lawfully stopped car to exit their vehicle as a matter of course. Likewise, courts have held that Texas drivers who refuse a lawful order to exit a vehicle may be arrested for interference with public duties in violation of Section 38.15 of the Texas Penal Code, which states that, quote, a person commits an offense if the person, with criminal negligence, interrupts, disrupts, impedes, or otherwise interferes with a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law. In the 2024 case of Castro versus Corey, the Fifth Circuit Court of Appeals, which has jurisdiction over Texas, held that a driver's, now quoting, repeated refusals to exit his vehicle interfered with a peace officer's duty in violation of Texas Penal Code Section 38.15. However, in reaching this conclusion, the court specifically noted that the district court had determined that the officers involved had reasonable suspicion for the initial stop and seizure of the driver, which, according to the Fifth Circuit, now quoting, confirms that the officers were exercising lawful duty as required by this statute. Additionally, the Fifth Circuit held in the 2007 case of Freeman versus Gore that an individual could not be arrested for a potential violation of the Texas interfering statute for disrupting an unlawful warrantless search of her home. The court concluded that a reasonable officer would have known that they could not lawfully search the home, and that, therefore, the homeowner was not, now quoting, interfering with the exercise of any authority granted to the deputies by law. Consequently, because the traffic stop itself was not lawful, the deputy could not lawfully order the driver out of the vehicle under the Mims case, and a court would therefore likely find that the driver could not lawfully be arrested for interfering, for refusing to exit the vehicle.
That's all right. We got a sergeant on the line right now. See? He's en route. So you can sit here or you can comply with our orders.
There is no vehicle. There is no reason for me to get out of my vehicle.
I don't know what's in this vehicle. You were hesitant on me asking if there were any weapons in the vehicle, and you said no, I don't have to tell you. So.
No weapons in my vehicle. And do not shine your flashlight in my eyes. I'm deaf.
You're deaf?
Well, that has nothing to do with a flashlight in your eyes.
Okay.
Anyways, I'm gonna run her.
It's a very common thing across the country as well. It's not even just our community here.
Hands on the hood. Anything you don't need that's gonna poke prod me? Pat you down for officer safety.
No.
Hands on the hood.
That's not a pat down. That is pull my bra.
It is definitely a pat down. We can argue all you want. I don't know why you are being so defensive.
You are not patting me down. You are feeling up under my bra.
Is that I'm allowed to?
The deputy claims that she is allowed to feel under the driver's bra as part of the pat-down, and the driver protests. During a Terry or traffic stop, law enforcement officers are generally allowed to perform a limited pat-down search of a person for weapons if they have reasonable suspicion that the person may be armed and dangerous. As the Supreme Court explained in the 1993 case of Minnesota versus Dickerson, quote, the purpose of this limited search is not to discover evidence of crime, but to allow the officer to pursue his investigation without fear of violence. A protective search must be strictly limited to that which is necessary for the discovery of weapons which might be used to harm the officer or others nearby. If the protective search goes beyond what is necessary to determine if the suspect is armed, it is no longer valid under Terry, and its fruits will be suppressed. Accordingly, even assuming that the officer had reasonable suspicion for the initial traffic stop, which she did not, and that she had a reasonable belief that the driver was armed, which is questionable, a court would likely conclude that the scope of the pat-down exceeded the permissible scope of a Terry stop and frisk. While an officer conducting a lawful pat-down may pat the exterior of clothing near the bra, a court would likely find that the deputy's decision to feel under the bra in this case was more invasive than permitted by Terry, as the level of intrusion appeared to be aimed more at discovering evidence of a crime rather than searching for weapons, especially since the deputy had no specific reason to believe that a weapon was concealed in that area.
No, you're not.
Okay. Where are you coming from today? Not your answer? Okay. Anything in the car that you're not supposed to have?
No.
Okay. Do you mind if I search the vehicle?
Yes, I do.
Okay. Okay. Stay right there. Can you make note that the occupant got out of the vehicle? And do we have any canine narcotics available? Huh?
Good.
Yeah.
It's too many of us.
Yeah. I'm gonna, wonder if that's enough for me to, because technically she was interfering.
Oh, yeah. I've done it.
I'm gonna call the DA. Did you call the DA before you? Yeah.
Yeah, well, my guy had physically had to remove him out of the car.
Alright, I'm gonna call the DA. Hello, this is Officer Norton with Montgomery County Constable's Precinct 5. I got a question for you. So, out on a traffic stop for obscured license plate. She has like bikes covering her license plate. I can't see the license plate. When I told her that I wasn't able to see the rear license plate, she argued with me and says that it's not obscured. I asked her multiple times to get out of the vehicle because when I asked her, when I asked if there were any weapons in the vehicle, she said that she didn't have to tell me. And finally, after asking her multiple times, she said, no, there's no weapons in the vehicle. I then asked her, okay, well, do you mind stepping out? That way I know, you know, for my safety, your safety, everything's okay. And then she refused to get out of the vehicle when I asked her multiple times. It took 4 other officers to ask her verbally. We didn't have to physically remove her. As I'm patting her down, seeing if she stuffed anything anywhere in her bra, she said that I was not doing a pat down, that I was illegally searching her. So I was gonna see if that's enough for interference.
Give me a second, I'm gonna look at something.
Okay.
Okay, here's where you're at. I'm with you. Technically, yes, you have the violation if you want to file it. However, there are some problems that will make you look terribly bad if you have to defend this case in court. The first one is the statute that I wanted to look at is that bicycles and motorcycle racks attached to a vehicle in normal and customary manner cannot be used as a basis for obstructing a license plate. It's actually spelled out in the statute. Now, that's problem number 1. Problem number 2, it sounds like she has a valid point about the search in saying that you patting her bra is not a pat down, it's a search. So the long and the short of it is, I would not do it, but if y'all really want to bite off that fight, yes, we'll file it.
No, I mean, I'm gonna go with obviously what you say, because I'm calling you to get your opinion on it. I was under the impression that if we weren't able to see a plate in the back at all, then it was obscured.
Well, I read you the exact language, and so you can see how you think it applies to your exact facts, because you're looking at your situation live. I'm not.
Yeah, no, I got you. Yeah, I mean, I physically can't see the plate, so like I legit had to go under the bikes as I'm pulling over the vehicle to see the plate. So
I'm giving you my assistance, so yeah, whichever way you want to go, it's fine with me.
Okay. All right. Thank you so much.
Thanks. Yeah.
All right. Bye.
We didn't get a response on any of the
That's there. You can disregard.
Were you wanting to speak with the sergeant, or?
You have any questions?
Nothing.
All right. Well, the sergeant's right here if you want to speak to him. If not, you're more than welcome to go on about your day.
Thank you.
Do you have any questions for me, for him? No? Okay.
After talking to the DA, the deputy allowed the driver to leave without further incident. Very little information is available about this encounter, and it's unknown if the driver filed a complaint or intends to pursue legal action. Overall, the deputy gets an F for maintaining a rude and unprofessional demeanor throughout the encounter, demonstrating a fundamental misunderstanding of both Texas traffic laws and the Constitution, and repeatedly violating the driver's Fourth Amendment rights. While the Supreme Court has upheld the constitutionality of traffic stops based on so-called reasonable mistakes of law, in this instance, the statute explicitly stated that it did not apply to bike racks, showing that the deputy was simply ignorant of the provisions of the statute that she was attempting to enforce. When the driver attempted to correct her understanding of the law, the deputy responded in a condescending and defiant manner, despite repeatedly being incorrect in her assertions. And while the deputy at least did not attempt to pursue interfering charges against the driver, she also did not apologize for or even appear remotely remorseful about unlawfully detaining her, searching her, and threatening her with arrest. This encounter underscores the critical importance of officers thoroughly understanding the laws they enforce, and highlights how a single misinterpretation of a statute can escalate into multiple constitutional violations. The driver gets an A for demonstrating a strong understanding of her legal rights, vigorously advocating for herself throughout the encounter, and attempting to educate an unknowledgeable deputy. That being said, I do want to generally caution against refusing officer orders to exit vehicles, as the Supreme Court has granted significant discretionary authority to officers to order drivers and passengers alike out of vehicles during lawful traffic stops. It is important to remember that a driver does not have to have committed an offense for a traffic stop to be lawful. Rather, the stop must be supported by at least reasonable suspicion. As we discussed earlier, reasonable suspicion can be based on a reasonable mistake of the law, as well as a reasonable mistake of fact. Or it could simply be that the driver's vehicle matched the description of a vehicle involved in a crime. Additionally, in determining whether a traffic stop is lawful, courts look at whether there was reasonable suspicion or probable cause for any offense, not just the offense that the officer actually believed was committed. In this case, the traffic stop seemed to be unconstitutional, but it is possible that a court could conclude that it was lawful based on information not available to us. As such, I suggest that citizens always comply with orders to exit vehicles, even when they appear to be unlawful. Let's move on to the next interaction. On August 18, 2023, Deputy Croft of the McCracken County Sheriff's Office in Kentucky was driving without his lights activated when he allegedly merged across two lanes without using a turn signal, nearly hitting driver Juniper Mulligan, who avoided a collision by slamming on her brakes. Deputy Croft parked in a McDonald's parking lot, as did Ms. Mulligan, and she walked over to Deputy Croft's vehicle and knocked on his window to talk to him about his driving. As a result, Deputy Croft detained Ms. Mulligan and called for backup, and Deputy Crone shortly arrived on the scene. The interaction that followed was captured on Deputy Crone's body camera.
So, pull up. I went in the 4 lane over there. I guess I cut from over. Never seen her over there. Of course, I can't say a whole lot of that. She comes up here. I'm getting ready to talk. She comes beating on my ankle. Scares me to death. I had no clue. Jumped out. She starts freaking boom, 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 boom. So I hit the recorder. Start recording. And she's doing the way she's been. I mean, she's yelling, screaming. She's disorderly. I think so. For disorderly.
You want to take disorderly? Take her disorderly. 36. Do you have his 23 last name?
Negative.
10-4. Got out of Kentucky ready.
God.
What's your name and badge number? What's your name and badge number?
I'll talk to you in a minute, okay?
36, of course, negative.
10-4.
Do you have a name?
Do what? I do have a name.
What is your name?
I told you I'll talk to you later.
4, negative, break.
Disorderly conduct and victim in the window. We might have minutes now.
That's amazing.
If you advise,
I would 100% say that's
type of
amazing.
vehicle for the 28, I'm not getting a
You
problem
in the window like that? I mean, yeah.
Ms. Mulligan? Turn around.
10-4.
Back. Arrest.
For what?
Disorderly conduct and menacing.
Menacing.
Deputy Croft informs Ms. Mulligan that she is under arrest for disorderly conduct and menacing. According to Section 525.060 of the Kentucky Revised Statutes, quote, a person is guilty of disorderly conduct in the second degree when, in a public place, and with intent to cause public inconvenience, annoyance, or alarm, or wantonly creating a risk thereof, he engages in fighting, or in violent, tumultuous, or threatening behavior, makes unreasonable noise, refuses to obey an official order to disperse issued to maintain public safety in dangerous proximity to a fire, hazard, or other emergency, or creates a hazardous or physically offensive condition by any act that serves no legitimate purpose. Now, even assuming for the sake of argument that Ms. Mulligan made unreasonable noise, the disorderly conduct statute requires that the individual act with intent to cause public inconvenience. Section 525.010 of the Kentucky Revised Statutes defines public as meaning, quote, affecting or likely to affect a substantial group of persons. This means, as the Sixth Circuit Court of Appeals, which has jurisdiction over Kentucky, explained in the 2011 case of Kennedy versus City of Villa Hills, that, now quoting, Kentucky law does not criminalize arguments and noise that disturb only police officers because such conduct does not risk public alarm. Indeed, because the First Amendment requires that police officers tolerate coarse criticism, the Constitution prohibits states from criminalizing conduct that disturbs solely police officers. Similarly, the Sixth Circuit held in the 1997 case of Barrett versus Harrington that, quote, it is evident that the First Amendment right to criticize public officials is well established and supported by ample case law, and that, now quoting again, freedom to criticize public officials and expose their wrongdoing is at the core of First Amendment values, even if the conduct is motivated by personal pique or resentment. As such, it is highly unlikely that a court would conclude Deputy Croft had probable cause to arrest Ms. Mulligan for disorderly conduct. Now, as for a menacing charge, Section 508.050 of the Kentucky Revised Statutes states that, quote, a person is guilty of menacing when he intentionally places another person in reasonable apprehension of imminent physical injury. Now, while it is possible that Deputy Croft was startled by Ms. Mulligan knocking on his window, this conduct almost certainly did not rise to the level of menacing, as there could be no fear of an imminent physical injury given the physical separation between Ms. Mulligan and Deputy Croft. Likewise, any so-called apprehension that Deputy Croft may have experienced could not be reasonable, as knocking on a window is a commonly accepted way of getting a park driver's attention and is not a threat of violence. Finally, it is abundantly clear that Ms. Mulligan was intending to try to speak with Deputy Croft, not place him in fear of imminent injury. As such, it is likely that a court would also conclude that Deputy Croft did not have probable cause to arrest Ms. Mulligan for menacing.
This is funny. Okay.
Don't
I'm going to do it.
Okay. Put your hands behind your back.
Oh, you want my keys home? Yeah, take my keys.
Don't be reaping anything out of her pocket.
Why?
Back up. Back up.
We'll give it to you, but don't be jerking it until we know. We don't know what you're pulling out of your
Hey,
Okay, then have a seat. Yeah, actually, we can't. You're under arrest.
You're under arrest. Stop it.
Oh, that's my dog.
I'm double locking these cuffs so they don't tie up on you, okay?
Yeah, you fucking up or anything on you?
All right, I'm going to walk you back here, okay?
I would like to give my mother my keys now.
Okay.
I would like to give my mother my keys.
No, so you're not going to do it. You're handcuffed, okay?
I know.
So,
I want my mother to go in my
listen,
pocket.
listen to me. You're
No,
under
I
arrest.
want
So
her
this is
to
a
take
search incident to arrest, okay? I'm lawfully able to search you after you've been placed under arrest, okay?
Sure.
I understand, but I'm just telling you how it is. So, obviously, I was the initial officer who was out here, so I'm going to make sure that he's okay with her having the keys, and if he's okay with it, then that's what we'll do, okay?
Sure.
Just want you to know, okay, I'm actively recording right now, so what I'm going to do is I'm going to search you well enough to ensure that you don't have anything that's going to harm me, okay? Is there going to be anything that's tucked on you that the jail's going to find when a female officer searches you?
Nope.
Okay, I appreciate the honesty. I think that's everything. Right. Oh, man, we got you guys.
Yeah, me too. May she have that?
Yeah, we can get guys.
And I would like, no, that's my wallet.
What?
My wallet is in my back pocket.
Okay.
Mom?
You have to check signal this up.
Do I?
Yeah. Something.
Mom, come take these things from him, please.
Alright, so you do want your mom to have cash, correct?
I want her to have my keys, whatever's in my pockets.
Yes.
I'd like to keep my chapstick though.
Make sure there ain't nothing folded up in here. Alright, is there anything in your back pocket?
Right side. Just don't touch it.
Yeah, there's my wallet.
Is your wallet in your back pocket? Can you go ahead and just grab that out with your left hand?
Sure.
Okay. No, absolutely not. Okay. Yeah. No. Come here. You're on the car.
I was just handling my property. On my mother.
Face the
33
vehicle.
for check welfare.
Space the vehicle. Yeah. Okay. Good.
2236 Homewood Avenue.
Take some side steps
Caller
to your
advising
left.
there's a female possible 218A. 218A.
What I'd like to do is I want you to spread your legs just like this.
We're currently public service right now. Thinks she's going to harm pets and chickens in the area. Unknown weapon. Via shoulder length, hair, black shirt, white shorts with flowers and Crocs.
Hey, unless you want to go in cuffs, give me those keys. Stand over there. Stand over there, or you're going to be arrested for interfering in this investigation. Stand back.
I'm just got her keys.
You're not grabbing anything on this car.
Occupant in the vehicle.
Stay there. Do not touch those keys.
Excuse me. I'm not a freaking dog.
I have a wand right here. This is a metal detector, okay? Okay, you spread your legs back. I want you to turn around and face me. Stand up. I'll take your hat off. Exit. I'll turn that AC on. Good. Yeah, I don't know why they're doing this today, but we're good. I'm going to read you something because you're currently placed under arrest, okay? You have the right to remain silent. Anything you say can and will be used against you in court. You have the right to an attorney before making any statements and have your attorney with you during questioning. If you cannot afford an attorney and desire one, the court will appoint one for you. You may stop the questioning at any time by refusing to answer further or by requesting to consult with your attorney. Do you understand each of these rights that I have explained to you?
Yes.
Okay. Keeping these rights in mind, you know you don't have to talk to me and you can invoke these at any time.
All right.
Do you wish to talk to me about what happened today that led to this? Because it's honestly, I don't know. I rolled up here and the situation was already happening.
All right. Will it affect my arrest?
Do what?
Will it affect this? Do I get out?
No.
Okay. Well, that cop, whoever, cut across 2 lanes of traffic.
We're at over here on the road.
On the bridge. Cut in front of me across 2 lanes of traffic, no lights, no signals. And I honked at him, and then I came here to tell him he was a bad driver, and this happened.
Tell me how you went about telling him that he was a bad driver.
I
believe that's where the problem's gonna
I just went
lie.
up and knocked on his door. I knocked twice on glass. That's it.
We could have went about this in a better way. You know that you can just go to the sheriff's department and say, hey, I want to talk with the sheriff. I've got a problem with what happened today on the road. Do you realize that's the way to go about this? Because listen, let me tell you something. I do not enjoy taking away people's freedoms. I did not get in this job to do so. And I hate that this is what it's come to today, okay? But I wish that on your side as well, I wish that we could have done better today.
All I was going to do was let him know he cut across 2 lanes of traffic. You know, if you're supposed to uphold the law, you should, actually follow the law.
I agree.
You should be aware of the laws he's trying to enforce.
Well, let me ask you this, man. Do you think if we could go back in time, you do this a little bit different? You think that it was appropriate? But I tell you, whenever you go there and you beat on his window and you put him in fear of physical injury, it's called
I
menacing.
disagree with that.
Well, I wasn't here for that, okay? I appreciate you being nice and cordial with me and talking to me. I promise I'm not a mean person, okay? I'm going to do my best to be able to have your mom take the car where it doesn't get towed, okay?
I appreciate that.
All right, well, I'll be back with you soon, okay? Can you feel the air?
Yes.
Okay.
After reading Ms. Mulligan her Miranda rights, Deputy Crone questions her about the incident. As we have discussed before here on ATA, the Supreme Court held in the landmark 1966 decision of Miranda versus Arizona that officers must inform suspects of specific details regarding their legal rights under the Fifth and Sixth Amendment before they can subject them to so-called in-custody interrogation. Although the initiation of a formal arrest will generally render a suspect in custody for the purposes of a Miranda analysis, courts have also found that Miranda warnings are required in some situations where a citizen is in custody but not formally under arrest. As the Supreme Court explained in the 1995 case of Thompson versus Cohane, quote, "Two discrete inquiries are essential to the determination. First, what were the circumstances surrounding the interrogation? And second, given those circumstances, would a reasonable person have felt he or she was not at liberty to terminate the interrogation and leave?" Now, in this situation, Ms. Mulligan had been formally arrested, handcuffed, and placed in the backseat of a police vehicle, so it is virtually inarguable that she was in custody and that Miranda warnings were required prior to interrogation. However, it is important to understand that there may be circumstances where Miranda is implicated even if a formal arrest has not been conducted. Conversely, courts have also determined that individuals who are placed into the back of police vehicles are not always considered to be in custody for Miranda purposes. As the Sixth Circuit Court of Appeals explained in the 2007 case of the United States versus Wright, quote, "Merely placing an individual in a police car does not automatically transform a Terry stop into a formal arrest. Instead, we look at the totality of the circumstances, focusing on the purpose of the questioning, whether the place of the questioning was hostile or coercive, the length of the questioning, and other indicia of custody, such as whether the suspect was informed at the time that the questioning was voluntary or that the suspect was free to leave or to request the officers to do so, whether the suspect possessed unrestrained freedom of movement during questioning, and whether the suspect initiated contact with the police. Therefore, even though Ms. Mulligan was almost certainly in custody at the time of this interrogation, there may be situations where officers are not required to give Miranda warnings prior to questioning citizens that they have placed in police vehicles.
Yeah, I'll open the window. She can talk to you. Would you like to come speak with her? You can talk to her, say whatever you'd like. I just ask that you don't reach in there or take anything. Just talk, okay?
What?
I still have my chopstick. Here's some tea. How are you doing, hon?
Could be better.
Like I said, I searched you. You're a woman, so I'm not going. I searched you well enough to make sure that you don't have any knives, guns, or anything that can hurt me. Okay? The chapstick that's in your pocket, you can just leave it there. Okay? It's okay.
Let me know the incidentals.
Yeah.
You'll just probably ROR right out. Okay?
Probably what?
You'll probably just ROR right out.
I don't know what that means.
They're basically, you're going to go up there, they're going to take your information, and they're going to release you on your own recognizance to come back to a court date. So
I have no way home, and I've got 7 animals I got to take care of.
all right. I'll make sure I let them know. I think we're going to be able to do that. So, but I've got to go over there and talk to them, so I'm rolling the window up. So just kind of hang back over there in the shade. Do you want this with Mom or not?
Yeah, she can have it.
Okay. Real quick. Your mom. I don't think that it was a good idea of what daughter did today.
I know
I was telling you, just like I was telling her. And she even said, she'd go about it different. I'm gonna put your seatbelt on you. Just go straight down, okay? Are those cuffs okay on you right now?
They're not really comfortable.
Well, they're not designed to be comfortable, but is your hands okay right now? They're not like numbing out or anything?
No.
Alright, well we ain't got that long. It's just a little short. Oh, there it goes. Alright, we're gonna go up there.
Ms. Mulligan was transported to a county jail where she spent the night before being released. Ms. Mulligan alleges that during her time in jail, she was forced to sleep on the floor of a crowded room, and that a jailer found a snake in the building and brought it to her cell to show the detainees. Ms. Mulligan fought the charges against her, and they were eventually dismissed. Ms. Mulligan also expressed serious concerns regarding inappropriate sexual advances and the mental health of the public defender assigned to her case. These allegations are discussed in detail in Lackluster's coverage of this encounter, which I've linked in the description down below. The charges were expunged in December of 2023, and Ms. Mulligan filed complaints with the jail and the McCracken County Sheriff, the results of which are unknown. Ms. Mulligan also filed a lawsuit, and the case was settled for $25,000, $5,000 of which Ms. Mulligan donated to a domestic violence crisis center. Overall, Deputy Croft and Deputy Crone get an F for arresting Ms. Mulligan without any legitimate cause to do so and demonstrating a clear clear deficiency of knowledge regarding Kentucky criminal law and the Constitution. Deputy Croft also maintained a belligerent and unprofessional demeanor throughout the encounter. And while Deputy Crone did behave more politely, he not only completed the unlawful arrest of Ms. Mulligan, but repeatedly scolded her for simply trying to approach a police officer in public to voice her concerns. It is not illegal to knock on a police officer's window, as any reasonable officer would clearly understand. And it seems that this arrest was yet another instance of the infamous offense of contempt of cop. Ms. Mulligan gets an A for attempting to confront Deputy Croft about his dangerous driving behavior, maintaining a relatively calm and respectful demeanor throughout the interaction, and complying with the arrest and challenging its validity after the fact. Ms. Mulligan's conduct during her blatantly unlawful arrest is an excellent example of how citizens should behave when they are unconstitutionally arrested, particularly in states like Kentucky, where citizens can be convicted of resisting an unlawful arrest. And although I would have preferred to see Ms. Mulligan invoke her Fifth Amendment rights when Deputy Crone interrogated her, she did not admit to anything incriminating because she had not committed any crimes. On the whole, Ms. Mulligan did an excellent job balancing compliance and verbal dissent, and I applaud her for fighting the criminal charges against her and taking appropriate civil legal action to hold the deputies involved accountable. Let us know if there's an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.